Yep, perfect.
Wonderful, wonderful. How about Team 6? How are we doing with audio visual? Can you guys hear me good?
Yep, we can hear and see everyone.
Excellent, wonderful. Well, welcome aboard to our competitors and to everyone to the grand final of the 2020 QUT Law Society and Ashurst Open Moot. Congratulations to Team 5 and Team 6 for finalising. What a great competition it's been. It's run smoothly, it's been enjoyable so far, and I'm confident that it's going to be a fantastic final as well. So I'm going to be using the next couple of minutes to run through how it's all going to work and run. I'm pretty sure that, you know, having gone through the prelims and semis.
I had some sound issues there.
Okay, good. I was worried that was for a second. I was like, oh no.
Yeah. It'll be back in a moment. Oh.
You're back.
Lost you.
I'm back.
Yep.
Good. Excellent. Sorry, there was a bit of a delay. Like I said, I'll use the next couple of minutes to run through how it's all going to work. Similar procedure to the prelims and the semis. For each team, you give your appearances to the judges. 20 minutes per team, that's inclusive of rebuttal. So just give the time for each speaker so that our timer, Jordan, knows as well. We'll be using the chat function for that. So per speaker, the 5 minute, the 1 minute more warning remaining, plus the time's up as well. So that's for the benefit of the judges and the competitors there in the chat function. Regarding that, I mean, it's been how it's been working for all the previous rounds, but did the competitors have any questions about that from me at all for the final? Good, excellent. And after that, I will, and after the rebuttal, we defer to the judges. We'll place the judges in a breakout room for their judging deliberations, and then we'll have the announcement for the winners and the final statements. Anyone have any questions from myself or Jordan before we kick off? Excellent. If we're all comfortable, then I'll place myself, I'll turn my screen off and I'll place myself on mute. And then the judges can then proceed with asking for appearances from Team 5 and 6, and then Team 5 commences. Excellent. Wonderful. Thank you very much, and best of luck for the grand final, everyone.
Thank you.
Before we start, again, what was just said, both teams, best of luck to you. And if there's nothing further, we'll get into character and take appearances and get going. So if you're both ready, both sides. Okay. So we'll take it. Sorry, Hamish.
No,
yes.
All good.
No. All right. We'll take appearances, please.
May I please court, Your Honour? I, Townsend, initials HS, appeal my learned associate, French, initials EM, on behalf of the applicant.
Yes, thank you, Mr. Townsend.
Mr. Townsend, sorry, how long will you each be speaking for?
I will be speaking for 9 minutes, reserving 1 minute rebuttal, and my learned associate will be doing the same.
Thank you.
And on the other side, respondents?
Your Honours, may it please the court, my name is Matthews, initial T, spelled M-A-T-T-H-E-W-S, and I appear as senior counsel for the second respondent, along with my junior counsel, Mr. Rao, initial R, spelled R-A-O. I will be speaking for the first 10 minutes. Mr. Rao will speak for the following 9 minutes, and we reserve 1 minute for sir rebuttal.
All right. Thank you. Thank you, Ms. Matthews. Yes, Mr. Townsend.
Thank you very much, Your Honours. Now, I'd like to begin with discussing submission A regarding misleading and deceptive conduct. Now, before Your Honours are satisfied that Ms. Carrington and by accessory CPL, Carrington Pacific Limited, are liable for breach of Section 1041H, you must be of the view that a reasonable or ordinary member of the audience to which the statement made on the ASX and to social media where it was received was led erroneously to a misapprehension of facts or a misconception. Now, the representation in question can be found in paragraph 16A of the facts. The applicants submit that representation A in 16A has the effect that CPL, at the time the announcement was made, had in their possession the design to a groundbreaking windmill that could substitute traditional energy resources. And the representation at 16B really was just to clarify the certainty in their view that they had such a windmill, in the use that they will be able to sell and market that windmill, and they will be able to replace and substitute traditional energy sources. Now, this line of reasoning regarding the word future in a representation can actually be found in the case of ASIC McDonald number 11 from 2009, specifically a paragraph 716 to 717. I'd like to quote directly the learned honour there, where he says, "It was submitted that the use of the phrase future claims highlighted the nature of the prediction involved." The learned honour there then goes on to say that that's not the representation the reader would get. Albeit a prediction was involved, the reader would understand that the message conveyed that the first two representations, that they were certain of those representations, and therefore it is submitted by the applicants that your learned honours should follow roughly the same reasoning as the facts are of similarities. Now,
sorry, in relation to section 1041 of the Act, so in relation to misleading deceptive conduct, could you explain to me in its simplest form how we can satisfy that section? So if we break it down to bare elements and what is required to meet that particular section and say it's a breach?
Of course, Your Honour. So the first element that the court needs to satisfy is what conduct is in relation to. Here, if we look at the case of ASIC and Narain from 2009, I believe, Your Honours, which is part of the ASIC and Citrafresh number 2 series of cases, that was found conclusively that in relation to when an announcement is posted, to the ASX, where it has material that could substantially affect share price, it is in relation to a financial product. Here, we can find that it's similar circumstances, and therefore that element would be passed. And the second element is if the statement itself was misleading or deceptive. As I touched on before, Your Honours must be convinced that a reasonable or ordinary person from a specific class in which a statement is received, here it would be the general public, as such a statement was made on social media, and whether that general or ordinary person would be led to a misapprehension of the fact.
Is the general public the only audience?
What was that, sorry?
Is the general public the only audience, or are there other class members that would be relevant?
No, Your Honour, there are other class members. The fact that the statement was posted to the ASX does have some significance. Those members would be of the more informed kind and would have a lesser chance of being misled, as most people who read ASX announcements generally have a greater understanding. However, the effect that has on being posted to social media, as can be found in the Madden and Seafoley decision at paragraph 76, is that the way someone reads a announcement to social media is a lot less detailed and analytical, as is done by that on the ASX.
Sorry,
now, Your Honour,
just to take you back a second.
Yeah.
If it's on the, so you said that the audience of the ASX is more likely or less likely to be misled, doesn't that go against you?
No, Your Honour, because what the applicants submit is that if the announcement was solely posted to the ASX, then it may be of a lot less likelihood that CPL and Ms. Carrington were in breach of the Act. However, because there is that additional class of persons that contains the general public in which the announcement was shared, it's that class of persons that are more likely to be misled. And it's those people who the Act in its intention is designed to protect overall.
Okay, so if you could spell out Ms. Carrington's actions or the publication in its simplest form, what is misleading and deceptive about what's happened?
So, as I touched on before, Your Honour, representation A, to effect, has the effect that it conveys to that audience that at that point in time that the announcement was published, Carrington Pacific Limited had a design of windmill that could substitute traditional energy and was groundbreaking, which, as we now know, was untrue. Now, the the actual fact of the announcement is actually irrelevant. When a person makes a statement, if they make it on the basis that it is factual, it doesn't matter what their real intention is. I will quickly touch on, Your Honour, reasonable reliance. Here in this case, as the statement was made regarding existing fact, the reasonable reliance ground is not available, as is stipulated in the ASIC and Citrafresh 2010 decision, Your Honour. Now, I am cautious of time, Your Honour. I would like to move on to Section 180 submission, with your permission.
Sure.
Thank you very much.
If my colleagues are okay with that.
Fantastic. Now, the main test for if someone is in breach of a Section 180 duty is whether a reasonable director in their position in the same company with the same unique skills and experiences would have acted in a way which caused the company to breach the Act. Now, here, we really need to look at the unique experience of Ms. Carrington herself. Previously, she was in a role where she was exposed to ASX disclosure and announcements, which then subsequently she saw those erroneous announcements be really the root cause of that company becoming insolvent. Now, looking at whether a reasonable director with such experience, how they would approach it, the applicants don't promote the conduct that caused the breach was the posting of the announcement, but rather her careless drafting and the use of emphatic terms over express words of opinion. Words such as, we possibly have a new design of windmill that may in the future, with more testing, be able to do this.
It's the fact under the impression that was fact. So is that really her fault? Is there not a defence available?
See, Your Honour, as I mentioned in the submission about misleading or deceptive conduct, even though she believed the truth of the statements, it doesn't mean that she could have taken further alleviating action of adding those simple words of express opinion.
Counsel, to be fair, I mean, she did take reasonable steps, did she not? She ran the wording by the board, and in using that future thinking aspirational language, she wasn't making up facts that weren't to be true. She was merely pointing out what steps Carrington Pacific had taken in this instance.
Now, Your Honour, the duty under Section 180 isn't to act in good faith, it's to act with due care and diligence. Now, you mentioned the board meeting. The applicant would like to submit that board meeting was only an hour long. For a 200-page report, that's 3.5 pages a minute that those directors would have had to sift through to approve the accuracy. Furthermore, Ms. Carrington at no point sought third-party expert legal advice on the consequences of posting ASX announcements, nor did she seek that.
If they're, already a pretty established company that has experience in ASX, do they need to get a third opinion?
Okay. I would like to reference the ASIC and McDonald case again, as I discussed earlier, Your Honour. First of all, may I request 1 minute extension to conclude my case?
Yes, I'm happy with that.
Thank you very much. In reference to that ASIC and McDonald decision, it is outlined specifically at paragraphs 324 and 325 that when it's the drafting of an ASX announcement, it is not a matter of reliance on outside experts to rely on. In the circumstances of this case, they relied on an actuarial report from a reputational and highly qualified firm, and yet the judges there came to the conclusion that even though they relied on them, they were still in breach of their Section 180 duty, and therefore should have taken much greater care in the drafting announcement itself to, I guess, indemnify, you could say, Your Honour, themselves of any chance to mislead or deceive. If you have no further questions, Your Honour, I would like to conclude submissions A and B.
Oh, that's good, Mr. Townsend. That case that you were just referring to now was McDonald, was it?
Yes, Your Honour. It is, if I can find the specific.
Yeah, I can see it cited through your footnotes a number of times. So I just wanted to make sure that that was the one that you were referring to.
Yes, Your Honour.
Yep. All right. Look, that's all good on my end. If my if my what's the phrase? I think if my sisters
colleague.
have nothing further to add, we'll move on to the respondent team.
I think maybe perhaps the junior council, or are we going to?
Oh, sorry. Yes. Junior council. Sorry. My bad. Yes, Miss French.
Your Honour, I will be presenting on 2 points. Firstly, that the business judgment defence is not applicable to Ms Carrington. And secondly, that Ms Carrington should be disqualified for a period of 4 years in order to pay a pecuniary penalty of $25,000. On my first point, that the business judgment rule is not applicable as a defence to Ms Carrington, Your Honour, we submit that to be a business judgment, there must have been a decision to act or not act in relation to matters relevant to the business operations. And furthermore to this, the case of ASIC and Rich supports the decision that matters of such as setting goals, planning, budgeting, and forecasting are matters relevant to business operations and are business judgments. We submit, though, that in this situation, Ms Carrington's post constituted an advertisement. It was not a business judgment. It was purely advertising the agreement to increase their stock price. It did not directly relate to the business operations, and therefore it was not a business judgment.
So sorry, isn't there case law about this type of situation? I'm thinking of Mariner Corp or Vocation, where these ASX announcements and then publishing about those announcements was considered in the context of business judgment rule?
Your Honour, we submit in this case that it's not a business judgment because it's an advertisement, and that even though it was posted to the ASX, the nature of the language was an advertisement. It wasn't directly related to the operation of the business.
But it was just replicating the exact announcement they posted on the ASX, which isn't really an advertisement. It was for the purposes of generating shares and revenue for the company. Isn't that not related to a business judgment?
Your Honour, we'd submit that while it might have been for the purposes of increasing stock prices and that isn't a matter of planning or setting goals or budgeting. It's purely an advertisement for the purposes of this, and therefore it's not a business judgment.
If I'm not with you on that point, what are your other key reasons as to why the business judgment rule shouldn't apply?
Yes, Your Honour. So we'd have a number of other reasons as to why the business judgment is not relevant. Specifically that to be a business judgment by her, she would have had to have informed herself of the subject matter to the extent that was believed to be reasonably appropriate. Furthermore, with reference to the decision as well, the necessary of importance and the costs relating to obtaining the correct information and the time available for obtaining the correct information. And this comes from the case of, again, ASIC and Rich. Your Honour, we submit that Ms Carrington did not meet her obligation to inform herself on the subject matter necessary enough to be a reasonable belief that she had. Again, it was a 200-page report, and this was only read in an hour-long board meeting. This is not a sufficient amount of time to understand such an intensive report in a new area of technology. It was just
amount of time. How do we know that they didn't, they've cross-referenced, they're relying on experts, all of these people that they've employed and paid to do a report and give them their findings. So what is sufficient?
Your Honour, we submit that they should have spent more time analysing the board meeting. Should have spent more time in the board meeting analysing the report.
10 hours?
No, Your Honour, 10 hours might be in excess, but it should be more than a single sitting. They only read the report on the 2nd of February and then posted on the 5th of February. There would have been time to go over the report and then come back again at a later date to go over what they'd come up with, as well as they could have also sought to seek some third-party independent advice on the report. The report was made by the Colby Institute themselves, who were endorsing their own technology, which we'd submit that they'd need another opinion on the matter to be sufficiently informed of that.
Okay, sorry, Nat, you go.
Sorry, do you have any case law to support your position?
We submit that the case of ASIC and Rich, which sets out the considerations needed to the considerations needed to be considered to be a business judgment in which the so the case of Asic and Rich sets out the elements needed to provide what a business judgment and the necessary informing of yourself.
So Ms. French, could you just tell me then, in your own words, what is the business judgment rule?
Yes, Your Honour. So the business judgment rule is that if a defendant makes a case in a business judgment in which they have informed themselves of the necessary subject matter, as well as they made the judgment in good faith for a proper purpose, that they did not have a material personal interest in the rule, and that they rationally believed that the judgment was in the best interest of the corporation, that they have a defence to 180.
So what evidence do we have, or what can you point to that shows that Ms. Carrington was not acting in good faith, did not have the business's best interest at heart, and was not making a proper judgment? Can you point me to anything apart from timing?
Yeah, Your Honour, we're not submitting that she didn't have the best faith in the company's decision, and that she didn't believe that it wasn't in the best interest of the corporation. We're purely submitting that she did not inform herself sufficiently of the subject matter.
Ms. French, the business judgment rule, as it appears in 180 subsection 2, it's got a number of elements there, and it's a bit lengthy, but do we have to apply a sort of objective judgment or a subjective judgment as to, an objective or subjective test as to those elements, or perhaps there's both subjective and objective elements? Can you just clarify what your submission is on that, or what the position is at law?
Yes, sorry.
And if that doesn't sort of make sense, then just in the case of Miss Carrington, so do we judge her decisions subjectively? So like what she thought was appropriate, or do we apply some, reasonable third-party objective standard to it?
Yes, Your Honour, we submit that it would be an element of both. It is a
Right.
subjective test, but it does have an element of objectiveness in a reasonable director.
So, Ms. French, I think what the question is, and I'd like to also, I'm not quite sure what the answer is it an objective test as to whether someone has the business judgment rule defence available to them, or is it a subjective test?
Yes, Your Honour, it is both. There is elements of an objective test. However, D does state that it was in the director's best belief that it was a rational one. Otherwise, that no reasonable person in that position would hold that belief.
But then it says under that, the director's or officer's belief that the judgment is in the best interest of the corporation is a rational one unless the belief is one that no reasonable person in their position would hold. So it's kind of going from subjective straight into an objective test, wouldn't you agree?
Yes, Your Honour.
So how, in light of this, how in your sort of submission would we apply the business judgment rule to Ms. Carrington, to the decisions that she made?
Yes, Your Honour. So we'd submit that in the element of informing herself about the subject matter to the judgment, which she believed to be reasonably necessary, we'd submit that the level that she informed herself to was not a level that would be a reasonable person would have informed themselves to, and therefore she did not meet her obligation to necessarily inform herself.
What is your strongest point on this particular submission Ms. French. So what is the strongest thing that you can point to that says the business judgment rule does not apply?
Sorry, Your Honour, may I request a 1 minute, a 30-second extension to answer your question?
Yeah. 1 minute or 2 minutes, as my learned counsel saying.
2, you can quickly answer my sister judge's question, and then I want to ask one question about pecuniary penalties because I know we're out of time. So 30 seconds to answer my sister judge's question, and then I'll ask you another one where you get a minute and a half to answer.
Yes, Your Honour. So we'd submit that on this point, our strongest point is that she did not sufficiently inform herself of the subject matter to an extent that would be considered reasonable by a director in her position, due to the nature of the short meeting, reading the report, as well as this was an area of new technology that would have been unfamiliar to her despite having experience in similar areas. This was a new emerging technology.
Okay. 2 questions, a minute and a half to answer them once I've finished asking the question. First one, what is the key reason that you say a disqualification order is justified for the period of time you're seeking? And 2, why do you say that both a disqualification order and a pecuniary penalty are justified in this instance?
Sorry, I just didn't quite hear the first question. What was it again?
What's the key reason you say that a disqualification order of 4 years is justified in this instance?
Yes.
And why do you say that both a disqualification order as well as a pecuniary penalty are justified?
Yes, Your Honour. So firstly, we would say that the strongest point for supporting a disqualification is that it is necessary to protect the public and shareholders and seek accountability of her actions, and therefore the disqualification is necessary to seek this protection. And on our second point, for why we believe that a pecuniary penalty and disqualification order are necessary, we submit that due to the serious nature of the contravention and the loss and damage suffered and her negligence in this area, that she should be subject to a pecuniary penalty as well as a disqualification, which the court does have the allowance to order both.
Thank you.
All right. If my learned sisters have no other questions, I think we will move on to the other team, and I think that's it. Yes, we'll move on to the respondents.
Thank you, Your Honour. May it please the court.
Yep.
I will be addressing our first 2 submissions, namely that Ms Carrington has not engaged in misleading and deceptive conduct in contravention of section 1041H of the Corporations Act, and secondly, that she also has not contravened her duty of care and diligence found in section 180 subsection 1. My junior counsel will address the following 2 points with respect to the applicability of the business judgment rule and the inappropriateness of the penalties requested. Your Honours, if I may take you to the first argument, we accept that the crux of this question before the court relies on the characterisation of the statements as misleading and deceptive, since it is clearly conduct which has been engaged in the course of, in relation to financial services. Your Honours, whether something is misleading and deceptive turns quite heavily on whether it can be characterised as a statement of fact or a representation with respect to future matters. The difference here being that a statement of fact represents a state of affairs as they currently are, whereas a representation with respect to future matters refers to future events. A useful contrast is provided by a case that applies the concepts we will be speaking about later of Australian Securities and Investments Commission and Citrafresh International Limited No. 2, which is a 2010 case reported in the 77th volume of the Australian Corporations and Securities Reports at page 69. Your Honours, may I seek leave to dispense with full formal citations for myself and my junior colleague?
Yep.
Thank you, Your Honours. In that case, out of 5 statements that were brought before the court, 2 were found to be statements of fact and 3 were found to be representations with respect to future matters. Of the 2 that were statements of fact, it is useful to refer to the first, which was that we believe we can now offer a global solution to reduce and eventually stop the spread of certain diseases using Citrafresh. That was at paragraph 22 of CitraFresh. That was a statement as to existing events, namely that CitraFresh said they currently had a medical product able to prevent disease. Contrast that with the statements at paragraph 26, 31 and 33 of CitraFresh, which were representations with respect to future matters, where the statements effectively said that CTF will market a range of barrier protection products and that this product will have a significant impact on reducing the transmission of STDs. Your Honours, if we can draw your attention to the aspirational and forward-looking language used in paragraph 16A and B, particularly phrases like in the foreseeable future, and the fact that a new design of windmill can offer a global, safe and environmentally friendly renewable energy source that could substitute traditional energy sources. The use of this kind of language goes to and supports our proposition that they were ultimately representations with respect to future matters and not statements of fact.
In CitraFresh, were those announcements with representations to future matters, were they held to be misleading and deceiving or not?
Yes, Your Honour, they were. They are helpful simply in the sense here that they help characterise the statements, but we would differentiate with CitraFresh on the basis that in that case, if Your Honours are with us with that these are representations with respect to future matters, the question is whether Ms Carrington had a reasonable basis for making them. And if she did have a reasonable basis, then the statements will not be characterised as misleading and deceptive. In CitraFresh, the director in question, Mr Narain, had no reasonable basis for making the statements. Here we submit that the evidence suggests that Ms Carrington did have a reasonable basis for making those statements.
Councillor, when I read the statement at paragraph 16, when you isolate the words as you have with could and can, yes, I see what you mean about future matters, and I take that. But when we read the overall context of the statement, it's pretty firm in what it's saying. With the overall context, I would think to an audience such as on the ASX or the general public would say, this is happening, this is fact. So I'd be interested to see what your thoughts are on that. Do you not think that the entire context is rather factual, as your learned colleagues for the applicant are submitting?
Your Honour, we contend that they are.
So responding directly to what the applicant is
yes.
saying in relation to that.
Yes, Your Honour. So effectively, we would make 2 points in response there. While we accept that the audience here is likely to be a layperson due to the fact that it was spread on social media, according to Justice Hayden in Fortescue Metals and ASIC, the audience can be assumed not to be naive and can be assumed to at least understand that there are risks inherent in energy infrastructure projects. Now, while we accept that there is a level of confidence in these statements, we dispute the idea that they are inherently statements of fact because they don't represent matters that are or a situation that currently exists. They are very qualified in the sense that they make statements as to what could happen, and even a reasonable layperson, we submit, would be able to recognise that the use of such language indicates that this is not a sure thing or a thing that currently exists, but is something that will exist.
What makes you say that they were qualified statements?
Your Honour, use of phraseology such as in the foreseeable future, saying that we do not have this now, but we will eventually.
Oh, I see, yes. Sorry, I thought you were in reference to the basis for which they've been able to make that such in relation to the Colby Institute report. What are your submissions in that respect? I'd be interested to hear. Should she have received other advice? Should she have dug further? It seems quite premature for her to base her sole decision on one report.
Your Honour, we would point to a number of facts in that respect. Firstly, this was based on a 200-page report, which is a summary of the ongoing 1 month's worth of research by two career researchers at an institute that specialises in environment and sustainability research. Furthermore, we would also point to the fact that according to the wording of the end of paragraph 13, sample testing had already been undertaken, as Ms Carrington requests that they complete sample testing, which indicates that sample testing was ongoing and had so far been successful, hence the results of the report, which we would posit have sufficient veracity for her to have made statements as to what would be a reliable prediction.
With so much at stake, shouldn't any reasonable and prudent director at least get a second opinion? Why is only one opinion okay in this respect?
Your Honour, we would point to the fact that these reports also seem to have been confirmed or matched similar reports that Ms. Carrington had read according to paragraph 14, where after reviewing it, she says that it reflects similar reports that she has read. And in that respect, we would note that the need to obtain a second opinion wasn't necessary in this case. If she had been making statements of fact and had been alleging that that the Carrington Pacific would have this technology within a specific period of time, then she may have needed a second opinion. The fact that she didn't specify the year 2025 as suggested by the Colby Institute to us indicates that she did recognise that there was a need to qualify her statements. Your Honour, based on these reports, we submit that Ms. Carrington had a reasonable basis for making these statements in paragraph 16A and B. And reticent of my time, if you have no further questions on that submission, I would take you to our second argument.
Ms. Matthews, can you just, before you move on, so that test, that I think it's the site refresh test in relation to future statements is just as basic as you're saying it, i.e., do you have a reasonable basis for making the statement? Is it really that simple?
Yes, Your Honour.
Yes.
It was right in the case of Forrest and ASIC, if that's helpful, where they did find that there was a reasonable basis.
Right. All right. Look, in light of time, move on to your next submission.
Thank you, Your Honour. With respect to whether Ms. Carrington has contravened her duty of care and diligence, we submit that it's first a question of what that standard is, and here it is an objective assessment based on what a person with commensurate skills and experience would do in Ms. Carrington's position. It's effectively a question, according to ASIC and Vines, paragraph 7213, of what the risk versus reward was. Now, here we characterise the risk as quite remote. Now, while we recognise that there was a risk of reputational and financial damage, it isn't just whether there was a risk, but the likelihood of that risk. And we submit that based on the fact that the statements were qualified and sample testing was underway, additionally, that the risk was remote. Furthermore, we'd like to draw Your Honour's attention to the fact that we submit the report was reliable, and we note that the applicants have raised the case of McDonald number 11 as reason for suggesting that reliance on this report was not reasonable, even though they were experts, because in McDonald they weren't allowed, or they weren't permitted to have used the experts' reports to have excused their conduct. But Your Honour, in that case, first of all, the statements there were quite different. They were statements of fact, and they were quite emphatic. At paragraph 121, they stated the foundation has sufficient funds to meet all legitimate compensation claims, compared to here, where the statements are qualified and future-based. Furthermore, those statements were based on cash flow models that were created by, Your Honour, I know my time has expired. May I request 1 minute extension just to summarise that final point?
Yes, from me.
Thank you, Your Honour.
Yes, I think sorry, I should check with my sisters as well. I'm happy for you to do that, but
Yes.
if they are, yeah, I think they are, yeah.
Thank you, Your Honours. The note we would make there is that that cash flow modelling was, in the judge's opinion, very clearly wrong. And not only was it very clearly wrong to someone who lacked financial education, in this particular case, the directors who had reviewed it had financial literacy skills, sufficient that they should have recognised very clearly that these models were incorrect. Here, however, Ms. Carrington doesn't have that same education, and the experts here were relying on ongoing successful sample testing, and it wasn't obviously apparent that the report's results or findings were incorrect compared to McDonald, where they were. Your Honour, For that reason, we submit that the risk was low and the standard of care was also subsequently low. Therefore, Ms. Carrington's review of the report was sufficient to meet that standard of care, but furthermore, she also went as far as passing it by the board, comparing it to her personal experience and requesting further testing according to paragraph 13. For that reason, we submit she has not deviated from her standard of care, and we request that the court rejects the declaratory relief requested. If Your Honours have no further questions, that concludes my submissions.
That's all good. Thank you, Miss Matthews. We'll move on to Mr. Rao.
May it please the court. My name is Rao, initial R, and I will continue the respondent submissions. Specifically, I will submit that firstly, the statutory business judgment rule, as contained in section 180, subsection 2 of the Corporations Act, applies in this case to ensure that Ms. Carrington can be taken to have acted consistently with her duty of care and diligence. And secondly, we submit that the penalties requested for by the applicant, namely that of a disqualification order of 4 years, as well as a pecuniary penalty order of $25,000, are unjustified in light of the nature, extent, and seriousness of Ms. Carrington's departure from her standard of care. Your Honours, turning to my first submission, we submit that the business judgment rule applies in this case. Contrary to the applicant's submissions, we submit that the relevant business judgment exercised by Ms. Carrington regards her decision, as provided for in paragraph 16, to make the announcements that Carrington Pacific will be able to market an enhanced range of windmills in the foreseeable future, with the hope that advertising the new product would help to increase the sale of shares in Carrington Pacific, as well as promoting the overall profitability of the company, as provided for in paragraph 15 of the facts. Your Honour, we note that section 180, subsection 2 of the Corporations Act, in relation to the statutory business judgment rule, prescribes 5 elements, all of which must be satisfied for the defence to be made out. We note that the applicant has considered that only 2 of these elements are an issue, namely whether a business judgment was indeed exercised, and secondly, whether the director informed themselves about the subject matter of the decision to an extent they reasonably believed to be appropriate. With Your Honour's permission, I will therefore tailor my respondent submissions accordingly. And in that sense, Your Honour, we firstly submit that certainly a business judgment was made in this case. The explanatory memorandum to the Corporate Law Economic Law Reform Program Bill of 1998, which first sought to introduce the business judgment rule in statutory form at paragraph 6.8, specified that the operation of the business judgment rule will be confined to cases involving the making of business decisions about operations of the company. For example, the decision to undertake a particular kind of business activity promoted in a prospectus would be the kind of business judgment to which the rule would apply. In this case, at paragraph 8 of the facts, it discusses that upon incorporation, Carrington Pacific published a prospectus outlining that the company would generate shares and revenue through renewable energy products and education. Therefore, the applicant's submission that Ms. Carrington's posts were purely advertisements to increase their stock price clearly accepts that her conduct was in the furtherance of a business activity provided for in Carrington Pacific's prospectus. That is, the generation of shares and revenue through the renewable energy products. The decision to issue an ASX announcement and media release advertising the company's future ability to market an enhanced range of windmills therefore gives effect to that business activity included in the prospectus and therefore amounts to a business judgment.
Counsel, is there any recent case law that supports you on this point?
Certainly, Your Honour. I would refer the court to the case of Asic and Mariner, wherein there was a decision to cause, wherein the director decided there to launch a takeover bid of another business known as Ostock, and also along with that decision, an ASX announcement informing the market of the director's intentions was subsequently made. The case there held that the relevant business judgment involved the decision to initiate the takeover bid, as well as informing the market through the ASX announcement that the takeover bid would be launched. Effectively, the director made a conscious decision to notify the market of that bid, and therefore that amounted to a business judgment.
And
Your Honour, we would see...
Sorry, Counsel, what do you say to the applicant's submissions that because it was circulated then on social media, that it becomes an advertisement?
Your Honour, we would state that the fundamental purpose that it was circulated on social media, as provided for at paragraph 17, was to ensure that the news could reach as many potential investors as possible. Therefore, fundamentally, the decision was to promote the company's business, and therefore regards the operations of the company in the sense that they were looking to increase the profitability of Carrington Pacific by advertising its future ability to market an enhanced and new range of windmills. Therefore, we submit that effectively advertising on the social media platform is of relevance. Thank you, Your Honour. Turning...
Conscious of time, I'm going to move you. I would like just your key reason to the second point you're going to raise in response to the applicant's submission about Ms. Carrington reasonably informing herself. And then you can move on to penalty.
Your Honour, sorry, I note that our internet connection just became unstable. I received the question as being moving on to the question of whether she made a decision on the basis of the information that she made the decision on.
Yes, just the
second point.
Key point, and then move on to penalty points. I'd like to hear on that.
Sure. Yes, Your Honour. So turning to the question of whether Ms. Carrington made a decision or made an informed decision, we note that the applicant has sought to impose effectively the same standard as provided for under section 180 subsection 1, that is whether a reasonable person, or rather whether Ms. Carrington acted as a reasonable person would in the circumstances of this decision. That's not the provision, Your Honour. We submit that section 180 subsection 2 subsection C of the Corporations Act provides that the business judgment rule only applies if the director informed themselves about the subject matter of the judgment to the extent they reasonably believe to be appropriate. That predominantly provides a subjective analysis as to whether the director believed that they were informed about the subject matter of the decision to a reasonable extent to make the relevant business judgment. Here, by reading over the 200-page report, as well as consulting with the board before issuing the ASX release, and allowing 1 week after discussions to publish the ASX release, we submit that that was a reasonable amount of apologies, Your Honour. We submit that those actions was appropriate for Ms. Carrington to submit that she reasonably believed that she informed herself about the subject matter of the decision.
Look, Mr. Rao, I'm sorry, I just have to ask a question. You heard what I said to your your opponent, Ms. French, about there being an objective and a subjective test. What you've just explained to us is the subjective element, but then it appears there's the objective element under D. So the director, what I read out to Ms. French before, the belief is one that no reasonable person in their position would hold. Does that change your submissions at all? Or how does that impact your submissions?
No, Your Honour. The objective analysis that you are speaking of under D is an entirely different question. That relates to whether the director rationally believed that the decision was in the best interest of the company. In that instance, there is some level of objective analysis required as to whether that belief that the decision was in the best interests of the company was rational, and that invites objective considerations.
Right. And are you saying that doesn't apply in this case, or what?
We're saying, Your Honour, that it does apply, but the applicant has conceded that section 180 subsection D is not in contention in this case. They limited it to whether a business judgment was exercised and whether Ms. Carrington informed herself about the subject matter to an extent she reasonably believed to be appropriate. The question of subsection D is not enlivened here according to
I understand it. We're limited. Yeah. Okay. We're limited to. All right. Look. Apologies for taking you off on a bit of a tangent, Council. But if you continue, I think to your points on penalty provisions.
Yes, Your Honour. Turning that to the penalties, we submit firstly that a disqualification order of 4 years is unjustified in the circumstances of this case, contrary to section 206C, subsection 2, subsection B of the Corporations Act. In determining the appropriate disqualification period, regard must be had to Justice Santo's list of factors as provided for at paragraph 49 of the case of ASIC and Adler, which includes the degree of seriousness of the contravention, the propensity of the defendant to engage in similar conduct, as well as the harm that may be caused to the public. Your Honours, in terms of the disqualification period, we would seek to distinguish from the cases of Gilfillan and ASIC, as well as ASIC and Rich, where there was a substantial departure from the duty of care that was imposed on the directors. In both of those cases, there was evidence there which suggested, and as the court held, that it would be abundantly clear that if the ASX announcement was issued, it would result in misleading and deceptive conduct to occur and individuals to be subsequently misled. Both of those cases involved a disqualification period of 4 years, and we submit that in that context, as the departure here, if any, is quite minimal, a disqualification period of 4 years is wholly unjustified. Turning, Your Honour, to the final question of a pecuniary penalty, we submit that if any pecuniary penalty is to be ordered, it should be in the lower range, that of $4,000 to $5,000, as the defendant acted on professional advice. There was only negligence that was involved as opposed to any deceitful conduct or any dishonesty. She previously held an unblemished career in that, as provided for in paragraph 10 of the facts, she was not reprimanded. Your Honours, I note that my time has expired. May I please request a 30-second extension to summarise that final point?
Yes, you may.
As well, so if you could, if my colleagues are okay with this, I'd like my question answered and then you can summarise your submission. It's a bit of a left field question. I'm just wondering, in relation to penalties and your submission on the lower end of the scale, is there any merit to considering that there's probably the capacity to pay a higher penalty in discouraging conduct where there has been actual negligence to other people in similar positions? Would it not be prudent in the particular circumstances to potentially make an example and a warning to other decision makers such as Ms. Carrington?
Your Honour, if the court seeks to act in such a circumstance, to adopt such a course of conduct, it may be that may be something that is reasonable in the circumstances. However, we submit that in these facts, the departure from the duty of care is not so grave that it warrants an example being made out of Ms. Carrington. If it was a situation such as there was a extreme or egregious departure from the standard of care in the sense that there was a bold statement as a lie, for example, in ASIC and Padbury number 2, wherein it was stated that $6 billion of funding has been achieved, as opposed to disclosing the fact that there were preconditions to that funding, and later those preconditions disallowing that funding to continue and be provided. Such a case would lend itself for an example to be made out of the relevant director. By making an example out of Ms. Carrington, effectively the court would be discouraging any director to make decisions that would fall within the business judgment rule, in the sense that they would be acting on somewhat incomplete information, yet within the bounds of section 180 subsection 2, the business judgment rule. Your Honour, if I may then complete my submission in relation to pecuniary penalty, we submit that in the lack of any dishonest conduct by Ms. Carrington, a low range penalty of $4,000 to $5,000 is sufficient. May I please the court, that concludes the respondent submissions.
All right, thank you, Mr. Rao. We'll go back to counsel for the applicant for the rebuttal. Mr. Townsend, are you doing that? Or Ms. French? You're on mute. I do that too, all the time.
I apologise for that, Your Honour. Yes, I will dedicate the entire 2 minutes for rebuttal for the applicants. Thank you, Your Honour.
All right. Yep.
Now, Your Honours, upon reflection of the submissions from the respondent, there appears to be two primary foundations that make up the bulk of their argument against the applicants. I'd like to start with the first, that they submit that the representations are to future matters. Now, they make strong analogy to the Citrafresh case. Your Honours, I'd like to refer to paragraph 22, and it's submitted by the applicants that that wording, which was found to be a statement of existing facts, is eerily similar to the statement in 16A. Here it says, we believe that we can now offer a global solution. And if you refer to 16A, Your Honours, the representation is groundbreaking research had revealed that a new design can offer a global, safe and reliable solution. So it's the submission of the applicants that Your Honours should follow the same decision and this authority in finding that it is a representation of existing fact. Now, I'd like to also quickly touch on the fact that they referenced the Forest and Asset case, Your Honours. First of all, this should be distinguished as the announcement was posted solely to the ASX, and why it was not found to be misleading was because of those astute investors and the fact that it involved international law with the state China party. Now, Your Honours, I'd like to touch on the second primary argument that the respondents used, the fact that Ms. Carrington at all times acted honestly and in pure reliance on the report. The applicants at no point debate that she wasn't relying on the report. This is true. However, as the case law heavily states, primarily McDonald in the paragraph I said before, where the outcome of posting such an announcement is of such importance, where shareholders can lose millions, it's not a matter for relying on outside experts when the ease of alleviating action, of simply putting a few extra words to make it of express opinion, that action itself is what constitutes the crux of why Ms. Carrington is in breach of her duty. Extending that onto the business judgment rule, I refer to the Daniels and Anderson case, Your Honours, from 1995, 16 ASCR 607, primarily page 665. Your Honours, I would like to request an extra minute to conclude on submissions C and D on behalf of the applicants.
Council, I'm going to say no. I'll consult with my counsel.
Yeah, I was going to say a minute's probably too much.
In relation to rebuttal,
Your Honours, I can complete it in 20 seconds. I just have one more submission to make in regards to the business judgment rule, if that is allowable.
Well, look, if we afford this, what's it called, this leniency to you, it's got to go to the other side as well. So,
that is completely acceptable, Your Honours.
I'm happy to run it that way then.
You could summarise very quickly your last point, Council.
Thank you very much, Your Honours, for this leniency. I would like to really conclude by outlining that the business judgment duty was developed to promote entrepreneurship and risk in running a business, something that really is at the core of our business sector. Now, no rational businessman, as is the case and requirement of 180 subsection 2D, would have chosen to use emphatic terms over express words of opinion when they know and that they have had experience with consequences that involved insolvency of the company they were at. Your Honour, if you have no further questions, I thank you for your leniency and I conclude the rebuttal of the applicant.
Thank you.
Mr. Townsend, just very briefly, you heard what Mr. Rao said about the contentious elements of the business judgment rule, that you basically accepted that the contention in this case was to 182C. Do you agree with that? Is that your case? That we're solely relying on that element?
No, Your Honours. We concede that subsections A and B regarding good faith are completely true in these circumstances. There's no objection that she never acted in good faith. It is the fact that in looking at the context as a whole, she, a reasonable director would never have rationally made that judgment with the knowledge Ms. Carrington had and without the proper informing themselves with the longer board meeting and third-party advice, as my junior counsel touched on.
All right, thank you, Mr. Townsend. We'll move over to the respondent, and yes, you can go on for an extra minute or so, given Mr. Townsend also had that that option afforded to him.
Thank you, Your Honour. We would make 2 points in response, particularly in reference to the first 2 points made by our learned friends. Firstly, we would seek to emphasise the difference in language between Site Refresh at paragraph 22 and paragraph 16A here. While they do use the language of can, the key qualifier in site refresh that renders it a statement of fact is the use of the word now, which means that it is a statement as to current facts. By contrast, the statement in paragraph 16A says that they can offer a global, safe and environmentally friendly energy source, but it is subsequently also qualified in paragraph 16B by the words in the foreseeable future. If we were to take the statement in isolation, it could be possible to try to characterize it as a statement of fact, but absent the word now and in context with the use of the words foreseeable future in the second statement directly below, it's difficult to reconcile how those two statements are analogous compared to the language in the representations as to future matters in paragraphs 26, 31 and 33. On the second point regarding ASIC and McDonald number 11, we again would draw your Honour's attention to the fact that the situation here is very distinct from the situation in ASIC and McDonald, where while the defendants there were held not to be able to rely on the information in that particular case was blatantly wrong. And furthermore, we would actually seek to ultimately, Your Honours, we believe that the applicants have mischaracterised our argument. It is not that Ms Carrington relied solely on the report, but rather she relied in part on that report to assess the risk in combination with her experience and the sample testing underway to essentially gauge that there was not a high risk and that in context or compared to the reward, it was only necessary to take the steps that she ultimately took. Your Honours, if I could be of no further assistance, that concludes our rebuttal and our submissions.
I don't have anything further unless my my colleagues do.
Thank you, Council.
All right.
We go into our breakout rooms now.
Yeah, we'll drop out of character.
Excellent.
Thank you very much, everyone.
Yeah, well done, both of you. That was high quality, but we've got to go and talk specifics and decide on a winner. So hang tight. Yep.
So Jordan,
Please,
you're the
I just realised I was on mute. Hello. I will take the judges into a breakout room, so you guys are fine to hang around for as long as this decision takes, and we will quickly deliberate and get back to you.
Wonderful.
Great.
Wonderful. Well done to both of the teams. What a fantastic final round. Really high quality.
Love that. Who would have thought corpse law could be so...
Yeah. But someone interested in public and international law corps, it's like, oh, this is...
Yeah.
Some
It definitely, you're not the only ones. It definitely has the ability to turn your brain into mush. Yeah.
But I thought the person who wrote it did a great job.
Oh!
Yeah. Butter him up, last chance. But no, that was...
I'm so sorry I brought him.
Right.
No, I saw you before and I didn't know. I thought you were competing and I was like, oh...
Earlier here dressed in business wear. Yeah.
Well, I felt that. I'm wearing jeans. So look, that's the beauty of Zoom only. I'm a bit
dispensing citations, all those kinds of things. And bless Hamish, what a superb advocate. But I think he was getting a bit muddled from time to time and went over time, even though it was definitely way over time.
I agree with Helen. I think it was a very high quality moot and the applicant did do really well. And I loved Hamish's natural advocacy style. It's really great to see. I get to see that a lot in mooting. So it was really good. But yeah, I think the respondent is the winner.
Yeah.
Anyway, yeah, I think the respondent for me is the winner based on the fact that they really clearly structured out their arguments. Their answers were really excellent. They did a great
it's
job.
not. I think you can hear me. I can't hear you. I don't know what's happening.
We can hear you now.
I can hear you, Gabe. Yeah, I just thought the respondents, I mean, they had the
Change
case
my,
line, they went through and put
audio
out there
devices.
just the classic Moot sort of thing, what's really required, the way
Oh,
that
here we go. I think I
Moot, all
figured
those
it out.
kinds of things. Can you
There
hear
we
us?
go. Yep, I got it now.
All right.
It,
So I
it
just think the
switched-
way that they
sorry.
structured their submissions, so they went through straight away and so what they were going to talk about, put a case line together. The case line is always really important, and the way that they answer questions and the way that they listen to the questions. And you could just see it was a very, very polished. Look, the applicants were excellent. They really, really were, but I really think the respondents were really surpassing.
So, yeah, I was going to say, look, I'll let you, Helen and Natalie, see if you can agree on a winner, and then if I need to, I'll
Hey, we need you to weigh in on this one. Come on, that's not like you.
I've seen these guys on Monday, and there was a lot of similarities about.
Well, what's
like
your opinion?
Yeah, I think the respondents have it. Yeah. It was the same on Monday. That's why I didn't want to go first. It was the same on Monday. They were very polished. They broke things down really well and took me through things as I sort of said to them, like if I was doing this for real and you were appearing in front of me, I'd have a lot of confidence in relying and just sort of trusting what you're telling me and then making a decision based on what you're telling me.
Golden rule of mooting is making it so simple you can't deny it.
Yeah.
And then in a rebuttal, I know Nat was thinking it. You got to slit the throat. You got to keep
I
going.
was like, I'm going to tell them.
We'll yeah, look, we'll tell them. We can tell them about that. But yeah, I don't know. He just he didn't want to. He wasn't giving up. And no, look, I'll tell him. I'll tell him in feedback. Look,
very good.
You wanted to go on. Your first point was good. In that you brought up the CitraFresh case and said that the wording's really similar. To well, with our facts, what our statement is here to the statements in CitraFresh. So that was a good rebuttal point. But then you kind of, when you asked for that extension and you pushed for it, like you just kind of lost it there. It really wasn't necessary to do all that.
Ask for extensions with rebuttal, and with rebuttal it is 1 or 2 points and that's it. Like you make it as short as possible. You shouldn't even use your whole time that you allocated.
Yeah.
A slit of the throat, like the jugular gone, like spurt.
Well, I've told you that, Helen, when I've been judging you reading. I've taught everyone that. I love it.
Yeah, Helen, if you want to make the slit of the throat point with them,
I won't do this. I'll just be like,
I will. I make it every
like a killer, like bong. Maybe we can give one piece of feedback each to each team member and then announce the winner.
Good idea.
Because anyway, good. So we're agreed. So what do you say? One piece of feedback to each team member.
Yeah.
That I think that's right.
You can do one piece.
Yeah. I'll try and keep it. I'll try and keep it succinct. But
maybe
anyway,
you can write some feedback for them, Gabe.
Sorry.
It's all right. No, it's all good.
Yeah, no, I've got some notes. That's sort of anyway. But all right. Yeah, look, we'll just talk to them.
Stefan, would you like us to just tackle it head on first, so then they can, or just wait till the end of feedback? What's best for you? Putting people out of their misery? Is that the way?
Yeah. Look, I would say if you're happy, I'll do a segue to introduce when you guys start to speak when we get back in the same room. But I would say the decision of the winners first. And then I suppose, so that they're not listening to feedback with suspense. I imagine it's probably once they know what the decision is, they can take in the feedback more objectively rather than just sort of sitting through it while waiting, I mean,
it's like a judge.
So I think that's probably the best. And that's what.
So I was just going to say, it's like a judge doing like all the sentencing remarks before getting to the final sentence where they find out if they're going to jail or not. Yeah. Anyway,
Exactly.
but yeah, Helen, I was gonna say,
yeah.
so you were totally stealing my questions there.
Oh, sorry. You told me to. You said.
No, that's good. That's good. But I was just I'm saying it's a good thing. I asked I've written down two of the same questions I asked them on Monday. So I had the same problem. I had that same problem with Hamish that you identified when he was talking. You sort of brought him down because he just raced through his submissions and he didn't really attack the point. And then you said, well, what is it about these statements that's misleading or deceptive? And I asked him the same thing because he did the same thing on Monday, and it actually got him to sort of look at the statements and say, right, well, that's what's said. And yeah. And then you said, I think, what else could have been done about the business judgment rule? I asked the same thing on Monday, like what else could they have done to sort of enliven that rule, like to gain its protection. And yeah, then they sort of went off onto, into that they could have gotten another report and all that and spent some more time. Anyway, well done. Like that's.
And think alike. There we go.
That's the same stuff I was dealing with them on Monday. So yeah, Justice Driscoll in the house. Yeah.
Who knows? One day.
For sure. Definitely.
All right, let's go back and talk to them, shall we?
Yes,
right.
indeed. I can go.
Cool. You guys may have noticed up in the top corner that the Zoom is recording as well.
Yeah.
Are you guys happy for, obviously I cut out the feedback and I cut out deliberations and everything and we kind of make it a more concise and digestible package, but are you guys happy with us sending it to the competitors and potentially publishing it at some point if you guys get a chance to review it?
I'm happy with that.
Yeah, that's fine. I mean, yeah, if you can cut out deliberation, that's fine. But I don't think we.
Yeah, or generally, deliberation and feedback tends to be just for the competitors. So
yeah.
That's why that's something like we would have probably advocated for you guys to give the winner before feedback anyway, just for ease of.
That's fine, because I was expecting this would probably be live streamed or something. So I would expect it to be published somewhere. Everyone wants to see it, so why not?
We were thinking of it. I think the easiest way just for control is probably to...
Yeah, the Moots, yeah.
Particularly because you guys jump into a separate room and chat about it all as well.
Yeah. No, I'm happy with that.
Wonderful.
Just put filter over me, okay? No, I'm kidding.
Photoshop a suit on me or
Just
something.
make sure a bit of lo-fi will do to me just well.
I will get into the, I'll close this room so everyone can jump back into the main room and we'll go into feedback and results. That's what I was trying to say. Wonderful.
Excellent.
Side ASIC and Ritual ASIC and Vines, it's like 7,000, paragraph 7,000.
Yeah.
Oh, that's crazy.
At least they had like a little summary at the top being like, oh, this is where we talk about it. I'm like scrolling down.
Well, that was like for the Casimatis one where they pretty much step it out with references. I'm like, oh, sweet. Thank you for that. Back in. Ooh.
As everybody
Hello.
jumping back in now, so we'll get started again shortly.
Fantastic.
Wait for Nat to jump in and Stefan.
So what we've decided, we'll announce the winner first. Ladies, if you have no objections, I'll do it. Or if you want to do it, you can.
Nat, are you in?
Huh? Yeah, I'm
Oh, yeah, there she is. Yep, got it.
Yep.
Sorry,
All
guys.
right.
Continue.
Yep. All right. Well, all right. So first thing, we'll announce the winner. So we've unanimously 3-0 made the decision that the winners tonight are the respondents. So congratulations very much, Tegan and Ruthvik. But look, it was a very, very good, high quality moot. And Hamish and Eloise, you also did an excellent job. So please don't feel too hard done by. You really did put up an excellent fight there. So really congratulations to both sides. what we propose to do is, I think, each of us will sort of go through each speaker and give a point of feedback each to try and sort of move this part a bit quicker. We might just we'll go Hamish, Eloise, Tegan, and Ruthvik in order. Look, I judged you all on Monday. A lot of, I think, the feedback that I've picked up are similar things that I picked up on Monday. Look, Hamish, your rebuttal again was, well, the stuff on the misleading and deceptive. Sorry, guys, misleading or deceptive. You've both made that mistake in your submissions. I didn't want to say anything to put you off, but it's an important distinction, ands or ors, right? Because misleading, one element, deceptive, a second. You really need just one for this one, not both. So it's an important distinction. That's sort of a general piece of feedback to you both. It's misleading or deceptive. So just make sure you get that right in the future. But look, Hamish, that rebuttal point that you pulled out with Citrafresh, you know, the wording being very similar in that case to the wording of the statements in this case. Look, that was a good point, but yeah, you went off on a bit of a rant there with the rest of the rebuttal, and we were really trying to wrap you up. The first part was, I thought was a good point. It was a really good point, but it sort of drifted off there towards the end. So you really need to, especially with rebuttal, just be quick and concise. Probably like a point or two. Don't sort of go on an all-out assault on the opposition's case. Yeah. So that'd be my point of feedback. But also on Monday, just quickly, I gave you the same feedback on Monday. You raced through your submissions. I know it's a lot of content you have to do, but Helen today and I on Monday, we both asked you the same question, basically. What is it about these statements in your submission that is misleading or deceptive? And we both had to bring you back to that central issue, because you've got all this stuff to say, and you've raced through like the fundamental issue of that submission. The point there I'm making is remember to attack or deal with the main points in issue in whatever it is you're doing in the case or in moots or whatever. Look, Helen and Natalie, if you jump in with some feedback for Hamish.
Do you want to just quickly like run through everyone, and then we can, that way it's just sort of a smooth sort of.
Oh, all right. Yep. Eloise, look, I think, were you feeling a bit more confident tonight than on Monday?
Yes and no.
Yeah. I thought you were a bit more fierce, a bit more, aggressive, brave tonight, with your responses particularly. So that was good. You also, I thought you tackled that question of mine fairly well. The one about, the business judgment rule, is there a subjective or objective element, or is there both? I think you gave me the right answer ultimately, which is there's both elements. But yeah, look, I thought your presentation, at least, because I know I gave you feedback about that, your oral presentation and the way you sort of dealt with the questions tonight was better than it was on Monday. So well done. Keep working on that. Keep keep working to be sort of assertive and not back down from, or don't be afraid to answer the judges' questions. So keep going with that. And yeah, I think tonight was a bit of an improvement on Monday. So well done. Tegan, look, very, very good. You took that test for misleading and misleading or deceptive conduct and really just simplified it down for me into its most basic elements. Generally, you did that through your whole submission. You really you really just broke everything down. You hit the main issues and dealt with the main issues really quite efficiently and appropriately. You also provided really good rebuttal. So an excellent performance, Tegan. And Ruthvik, you also had a good performance. I like the research that you did, that extra research about the bill that introduced the business judgment rule. That's always quite helpful. Some judges decide, cases of interpretation, they actually go look to the source material, like what does the second reading of Parliament, what did they say about what its purposes was? So that was good. But yeah, look, my sort of main contention with your submission was, I don't think the opposition conceded that the issue on the business judgment rule was limited to subsection 2C. And I asked Hamish that, and he said, no, it's actually, we're dealing with the whole section. So I'm not sure what the position was, whether you prepared it that way and went that way, because I don't think that was the correct position. I guess the point I'm trying to make there is make sure that your submissions, when you're talking, you're listening to and you're dealing with what the opposition says. You're reacting to it, actively reacting to it, because I think that was an important point, and it didn't go the way that I think you said it did. So yeah, while it was a good performance, that sort of I would say would be the point to work on for next time, is make sure you deal with don't just say it's a particular way when it isn't, and react to the opposition's whatever the opposition's saying. Make sure you react to that, and it's a skill. Like, you have to do it on your feet sometimes, and makes your brain hurt sometimes when you're doing it, and particularly with corpse law. But anyway, look, that's really all I've got. I'll hand over to the other to Natalie and Helen. But look, excellent job, everyone. It's really nice to see, you all preparing to such a high standard. So keep it up.
Thanks, Gabe. Well, I'll start with Hamish. Hamish, I think you're an excellent advocate. You're so passionate and you come across so confident, and that's really, really good to see. If I can give you a bit of feedback, it's just that you need to simplify what you're saying, because you start talking saying all of these things, and because you're across the case, but I haven't read everything to the extent that you have. So if you can simplify it for me and tell me, first of all, what you're going to say and why it's important, and then tell me what the law is. So what is the misleading or deceptive conduct, and tell me why. So if you can simplify things and make it so simple that I can't disagree with it, then that would be great. But advocacy wise, absolutely fabulous. Eloise, You presented so lovely. I want you to know that what you have to say is important, and you can be really forward with what you want to say. You can be confident. You don't need to be worried about being timid or overly polite. The judges are fine. They want to hear what you have to say. So please be bolder with what you have to say. In terms of your actual content, when I asked you the questions right at the end, we asked you a very specific question, you absolutely nailed it. So you came out with the answer that we were looking for, and that was really impressive. And I like the way that you stopped to think about the answer to the question. So that's really important. Don't be afraid to take 30 seconds, even if it's time, to formulate your answer instead of rushing into something. But you guys were really brilliant, and I really applaud your effort tonight. Absolutely amazing. Please keep mooting. For the respondents, Tegan, your presentation, everyone was amazing advocate tonight, but I think that you were the most impressive advocate tonight. I really, really was so impressed with the way that you formulated everything, the way that you structured everything straight up. I immediately was like, this is where they're going. I understand their case. I see what's going on here. I'm picking up what they're putting down, and that's really important when you're opening submissions and you're the senior counsel. I honestly didn't think that I could find anything to fault you with. I really was so impressed with everything that you had to say. I couldn't disagree with anything that you had to say. I mean, I was struggling to ask you questions because it was that simple that I couldn't disagree with it. So thank you very much for that. And your dispensing the citations is always a nice touch as well. Now, I'm sorry, is it Ravik? I want to make sure I'm saying your name properly. Sorry?
Vic's fine. Vic, okay.
Sorry, I wanted to make sure I'm saying your name correctly. I also love the way that you pause to answer questions and think about it before rushing into things. That's so important. It may seem like, ages to you, but it's only a small pause in the grand scheme of things to everyone else. And I liked how you picked up specifically what the applicant said and that you addressed that specifically instead of going into everything else, and how you immediately thought on the spot and tailored everything. With one point of rebuttal for everyone, rebuttal is your opportunity to get one final say. It's not to go into more submissions or try and squeeze in things that you didn't get to say. It's try and pick 1 or 2 points. One is the ultimate, just to absolutely railroad the other team's case. If there is one thing that you can do to discredit them and make them seem stupid, you say it. It's not an opportunity to go through everything else. In mooting, we used to call it at uni a good slit the throat. So get the jugular, not lots of little stabs, one swift movement. So don't take up the whole time. If you can say it in 30 seconds and finish it, that's really powerful. That's all I have to say. Thank you, everyone. That was great.
Thank you.
Well, basically, I second everything that Helen and Gabe have said. I think they picked up on excellent points of feedback, and I thought that it was a really high standard of Moot, so well done on everyone involved. Hamish and Eloise, did I get that right? Even though you guys didn't win this round, you should be really proud of yourselves. You did a really great job, and I really encourage you to keep up with mooting and keep trying. You're really excellent, and the more you practice, the better you'll get. And mooting opens up so many doors for you down the track. So just keep carrying on with it. Hamish, my key piece of feedback. Well, first of all, the thing I really liked was your natural advocacy style. It's so really pleasing to see how naturally you engage with them. And don't rely on your notes a lot. That was great. I what Helen said with her main piece of feedback to you for simplifying things. Something that will help you with that is some good signposting. So at the start, you really just jumped into your submission without signposting and giving us a clear picture of where you're going to go. That can assist greatly with simplifying your submission. Eloise, I really loved the way that you answered questions. We were starting to hammer you there a bit, and you didn't back down. And towards the end, you gave really clear, great answers. And when I asked you those 2 questions at the end and told you very specifically what I wanted, you gave them to me. You didn't keep trying to go on with your submission, so that was really good. I think nerves and stuff made you laugh a little bit and things like that. They're just nervous ticks that they'll go away eventually. But yeah, I think you did a really great job. Vic, can I just say you did an excellent job at taking on the feedback that I gave you in the previous round. I'm sure the other judges gave you, because yeah, I really saw, like, even though you did excellent last time, you really stepped up again this round. Excellent job at really taking on board feedback. The thing that you did really well this round was answering the questions and taking the time to then give your answer. And yeah, really excellent job at responding to what the applicants put forward. Tegan, I second Helen. I really couldn't fault you a lot. You're a really excellent advocate, and you're really good at just setting out submissions very clearly and concisely. You're across the law. Your answers were excellent. I just think you did a really excellent job. I don't really have a lot to fault you on, to be honest.
Thank you.
But across the board, I was really impressed with everyone.
All right. Do you guys have any questions for us?
No, my only one would just be, because I tried cutting it down, but yeah, that definitely, like, moving into it, I was like, yeah, I definitely need to cut this down more. My only worry was not including information that I thought necessary. How would you, I guess, choose to cut and what to put in?
With a moot,
Sorry, Helen, you go.
with a moot, you're never going to be able to put in everything that you possibly want to say. It's not a trial that goes on for 3 weeks. You don't have that opportunity. And there are so many things and arguments that you can go with. So you've got to pick your strongest ones. You've got to read your problem always tells you what you need to focus on. You need to stick with that, and you need to stick with your strongest points. And if you can stick it in your written memorials, and then refer to your written memorials for the rest of your submissions, or when you're asked a question that wasn't part of your original submissions, you can always find a sneaky way to put in your extra material and seem like a genius on the spot. That's the way I used to do it. But otherwise, you just got to go with your strongest stuff, and you're never going to be able to include everything that you want to say. Get your winning points out, your 3 best.
Great, thank you very much.
There we go. I mean, on Monday, I think I talked to you both rounds. I think I mentioned the concept of forensic decision making when you get into practice. Yeah. So that's exactly what this deals with, Hamish. Here it's easier because you're told the points you have to cover in the moot, but in practice you may have 7 potential arguments or something like that, 7 grounds of appeal or something like that. But upon further investigation, like you as counsel, particularly as barristers, you got to make that call. How much sort of weight, how much validity does this argument have? Like, am I just going to piss the judge off if I run this?
The dignity of your case.
Yeah. And I mean, I've had it before where clients will say, "Oh, do this, do that. I want you to say this for me," and it's like, yes, all right, but if we look at the evidence that supports this point, I mean, I wouldn't. And you sort of have to talk to them then and say, look, in my opinion, as counsel, as your legal advisor, I suggest or I would advise that we don't proceed with this point. You have that power, you have that ability to make those in practice, those forensic decisions about how the case is conducted. But as Helen said, go, your strongest points at the beginning, try to, in mooting, I mean, try to sort of I mean, you had your two main submissions that you each had to deal with. You have to, sort of, I think as Helen said, two or so main points, 2 to 3 main points per submission, and then move on. Yeah.
I have something very briefly to add to that question. It's also about reading the bench as well in mooting and in practice. It may be very clear that the bench is not with you on a point and you're just wasting time flogging a dead horse, basically. There was one point, Eloise, where I was hammering you on one point and I clearly wasn't buying what you had to say. In that instance, you can recognize it. If your Honor clearly is not with me on that point, or if your Honor is not with me on that point, I will then turn to my alternative argument. So it's all about reading the bench too, because that can give you some good tips on how much time to spend on particular things.
Thank you very much for that. Yeah, that was interesting. Sweet. Is that it? We out?
Is that it? I'm very hungry.
All
Yeah,
good.
I'm starving.
All right. Again, well done, everyone. Congratulations.
Thank you so
Yeah.
much.
Thank you, judging.
And I'll just wrap up while I think
I think
one of the competitors left. But look, I'll send an email anyway. I was just going to say thanks to everyone. This was a really, really, really smooth grand final. It was probably a really good way to finish this year's comps as the last one that we've got for the year. So transitioning to Zoom so suddenly was a challenge, but this really does nice way. Well done to Team 6 for your victory evening, and I think Team 5 are not here, but obviously well done to them as well. Both submissions were great from my end. Just spectating was really good. Judges, thank you so much for your help and your assistance. It's much appreciated. To the judges, if you want, you can stick around the Zoom chat after Team 6 have left. I can just have a chat with you after when it's all done, as you do. But with Team 6, we'll try to get those final communications regarding, the winner-up commemoration stuff through the email as fast as we can. We'll be as prompt as possible.
Thank you.
So just keep an eye out for emails for that. But congratulations once again. Did you have any questions from myself this evening?
No. Thank you for organising this.
Yep.
Not a problem at all. Well done again then. All the best.
Thank you.
Cheers. Thanks, guys.
Bye.
Thanks you.
Good night.